for the Kenyan public of 40 million euros, which was the contract price in the supplier's credit agreement. As already seen, the SCA was validated by opinion of the Attorney General and cannot by any stretch be described as a purported contract. It was a binding contract between the GOK and Sounday. It cannot be a purported contract in those circumstances. This charge is wholly unsupported by evidence, and I hereby dismiss it. Next, the count 2 and the alternative. Again, as already found and emphasized in the evidence of Dockers at Chapter PW10 and the Honorable Attorney General, then the SCA was a valid and legal contract. The payment of 3% of the contractual sum as arrangement, commitment, and management fee was a legal payment and proper obligation of GOK under the clauses of the agreement. The payment of euros 1.2 million under the contract was therefore neither fraudulent nor an illegality, in my finding. It was not established in the evidence that the fifth and sixth accused persons were the beneficial owners of the amount paid by GOK. The evidence does not support this count, which must fail and is hereby dismissed. The same fate must befall the alternative count to that count, which is also hereby dismissed, for the reason that the sum of euros 1.2 million paid under the SCA was not the result of any demonstrated corrupt conduct or illegality. Because it was not established that the fifth and sixth accused persons were beneficial owners of the said amount paid by GOK, it cannot be said that they, to quote, the state received the payment, and no such evidence is available by the state. In count 3, the evidence establishes that the first, third, and fourth accused persons were not from the contracting ministry and were only performing legal and administrative functions in relation to the procurement. The first accused, as Minister of Finance, who is now deceased, had the obligation to grant exemption under Section 3, subsection 2 of the Procurement Regulation 01 and sign the special instrument under Section 7 of the then External Loans and Credits Act, Cap 422 Laws of Kenya, which he did. The third accused had the legal obligation to countersign the SCA upon delegation by the minister and to sign the pay advice as a forex payment and sign for all and any borrowing on behalf of the Treasury as the regulations require. The fourth accused, as head of the Debt Management Department, had the administrative duty to review and help negotiate the terms of any borrowing agreement and accordingly advise his bosses, the first and third accused, to aid grant of requested approvals. Because the first, second, and third accused persons were not involved in the procurement, they had no planning obligation under the laws of procurement in place at the time. In relation to the second accused and generally, the evidence does not support the allegation that there was no planning in relation to the modernization project. As such, count 3 is for dismissal and is hereby dismissed. In count 4, the evidence shows that the first accused, who is now deceased as minister, having exempted the procurement in the modernization project under Regulation 3, Sub-Regulation 2 of the Procurement Regulations 2001, no other regulation, including Regulation 6.2, was applicable to the procurement. That exemption ousted all the regulations. As such, whether it was for better or for worse. As such, the second accused had no obligation to comply with that regulation. And therefore, that charge, to the extent that that charge relies on that regulation, has no basis and is dismissed. Count 5 and 7. The evidence does not show that there was any failure on the part of the second and third accused to follow the law on procurement to the extent that it applied to the SCA. The evidence shows that the SCA was deemed valid by opinion of the Honorable Attorney General, and both the second and third accused were under legal obligation to sign on behalf of GOK. Their signing of the SCA in those circumstances did not improperly confer any benefit upon Sounday, and count 5 and 7 are hereby dismissed. Count 6. The payment of euros 1.2 million by GOK under the clauses of the SCA was a valid and proper contractual payment. The role of the third accused was to countersign the SCA, and his signature alone could not confer properly or improperly the benefit alleged in the count and upon Apex Finance Corporation. The evidence shows that the payment of euros 1.2 million upon Apex Finance Corporation was drawn from the budget of the contracting ministry under duly approved votes, R1 and D1, if I still remember them. In these circumstances, recurrent 1 and development 1, I think, in these circumstances, this count cannot stand against the third accused and is hereby dismissed. In view of the foregoing, I therefore conclude and determine that in accordance with the principles applicable, the state has failed to make a prima facie case sufficient to warrant the calling of the accused persons and any of them in the respective charges preferred against them to make a defense. Orders are that upon the foregoing conclusion, I agree with defense submission that an order of acquittal should issue, which I hereby do in relation to each of their 5 accused persons before the court in each charge preferred hearing against them respectively. The state has a right to appeal within 14 days. I'll process it and have it ready for parties to pick within the next, today, in the course of the day. Mr. Ong. Yes.
The first application is taking its time to go through volumes and volumes of evidence, thousands and thousands of pages, to deliver a reasoned ruling within a short period of time. And for my colleagues, I think it was a pleasure defending this matter alongside 2 senior counsels, actually 3 senior counsels, and my colleagues Sadia and Hadija, who I must thank for their industry during the research period. Congratulations. This was a big fight. Thank you very much. We have been vindicated. Yes.
I only just sent him a message.
Sorry, the mark is gone. The mark is now gone. What was the rest? In brief, the court has found that the Anglo Leasing contract subject to this case was a valid contract. It was a legal contract. It was authorized by the Attorney General, and in very brief terms, this did not constitute a crime. The businessmen and the government officers who took part in this transaction did nothing wrong. They've been acquitted of all charges. Every single count has failed. The court has also said that in the course of the trial, the investigators failed to call crucial witnesses. They failed to call important witnesses in the case, and that finding makes their case very weak, and they could not sustain. They did not provide enough evidence to support the charges. I think that is the essence in brief. In very brief terms, is these transactions used to take place from the 90s. The supplier subject to these charges supplied guns to the country from the 90s. This particular transaction was nothing different from all the transactions. We don't know why this one became subject of a charge. We suspect the charges were brought for other motives other than the fight against corruption. And on behalf of my client and my co-counsels that we acted with in this matter, I think this now marks the end of all Anglo Leasing and Anglo Leasing related cases. We should now close this chapter and move on with our lives, isn't it? Thank you very much.